I had mentioned before, then I had mentioned because the matter could not be listed before Honorable Justice A.K. Mahapatra. That's why, my lord, I mentioned for Honorable Court, Honorable Chief Justice, I sent this matter to your hospital. It was before Durga Puja vacation, my lord. Then my lord could not change the division bench. That's the thing.
It might have been assigned to some of
My lord, it is because it is assigned to your specific direction is there. The judicial order.
Check it out.
Yes, ma'am. That is only the yes.
Assigned, then it will.
Yes, madam.
One CLMC, my lord, one CLMC for
Oblige,
press
Certificate. It will come. Need not mention, it will come now. We will take it up because there is no other assignment. We will say here this.
Yes, matter. Yes, madam.
Give it. Item 1. Yes.
Please, Your Lordship.
Yes.
That's it. Say, I have an innocuous prayer. So for the expeditious trial of the city case number, I pray target the city case within a stipulated time.
See, the FIR is somewhere in 2022.
Yes, Your Lordship.
And the charge sheet is filed, I think, the
23.
charge sheet is filed
Charge sheet filed
May
on
2023.
yes
So why should
7/5/2022.
What? How many witnesses are?
Lordship,
cited?
nothing has happened in the meanwhile, but
Here.
the accused person are delaying. Your Lordship, at
What is
kind-
delay? See, why should you get priority over the other?
Lordship, I am the informant. Your Lordship may see 307 is
but
there.
you try to appreciate one thing.
Yes,
It is only May. Charge sheet is filed in May.
no doubt, no doubt.
Charge it might have been framed by now, isn't it?
Lordship, kindly have a glance to page 20.
I think it is bit premature.
Wait for some time.
Better you wait for some time.
Oblige.
Better.
Lordship, it is may lie over so that
So I want to dispose it up so that you can see. If it is hanging, then nothing will happen. I'll give some observation,
yes,
which may help, but at the same time I'll dispose it up with some observation.
oblige.
Because it is premature at this stage. So it is, see, why should you march over the people those are waiting?
Lordship, one thing I pray.
Yes.
Your Lordship may not say the language that it is premature. That will
No, I know that. I know that. It will not hurt you.
no,
It may help you, but it may not hurt you.
may
That way I
yes, sir.
okay.
Yeah.
Before. By way of the present petition, the petitioner is seeking a direction from this court for expeditious disposal of the trial.
City case no sorry.
Trial in CT case number, the CT number 173 of 2022. And in connection with the Paradip PS case number 62 of 2022,
Pending in the court.
pending in the Court of Additional District Sessions Judge,
Kujang.
Kujang. From the perusal of the record, it appears that the FIR was concerned FIR was registered on 2/3/2022, and subsequently thereafter, the charge sheet has been laid down by the investigating agency on 7/5/2022. 7/5/2022. Next paragraph. No doubt, the expeditious and speedy trial is a constitutional right of an accused. Therefore, at the instance of the informant, this petition may not required to be interfered by this court. Having said that, this court expects that the trial court will take appropriate steps for a expeditious disposal of the trial.
I'm obliged.
The petition is disposed of.
Obliged.
Item 2.
Yes. 2. Password.
Item 3.
3.
Item 3.
Nobody there. Password.
Item 4.
Yes.
There my lord, the petitioner challenging the filing of the final form on the ground of no clue. That is my lord, at page, Annex 2, my lord.
Sorry?
Annex 2, page 13, my lord, 1
Yes.
3, my lord.
Yes.
Wherein, my lord,
You are the
I am the informant,
informant.
my lord. And so far the allegation is concerned, my lord, that the accused person, my lord, has forcibly taken away 3 vehicles of mine, my lord. And forcibly kidnapped me. Subsequently, with a threat, my lord, on the gunpoint, my lord, they took some signature from the blank papers, my lord. And in view of that, my lords, even if my lords, immediately after the FIR incident, I have lost the FIR, but it didn't register, my lords. Subsequently, my lords, the concerned police station assured me to register at the station directly. And thereafter, my lord, when I came to know that my vehicle was sold by the accused person, my lord, I lost the FIR and it is being registered, my lord. That is under Annex 1. My lord. And subsequently, without proper investigation, even if this is the fact that, my lord, the 3 vehicles has been stolen, my lord, they completed the investigation, submitted final form on the point that false FIR.
Then what is the procedure after filing final report?
The protest petition, there is a provision for protest petition.
How 482 is maintained?
But your lordship may kindly see, after prima facie, my lord,
Why you exhaust the remedy available under CRPC? Unnecessary, you get invite some observation for 482 court. That option is also closed. Why suddenly coming to the High Court, the real remedy which is available under the
Right.
CRPC, you are unnecessary, hampering that. It's better that you file.
with that observation, lordship may dispose of, my lord.
Otherwise, also you have right.
That I know, my lord.
Let me go write down. The petitioner is the informant. And you are the author of the FIR?
My lord,
You are the author of
my
the
lord.
informant. The petitioner, being the author of the FIR, put the criminal law into motion against the accused person by registering the FIR on 21/10/2022. After investigation, the police has now filed final report on
My lord, final report on 29,
27 to
27 to 2023. My lord.
27 to 2023. At this stage, the informant has filed this petition seeking interference of this court. Also, this interference. However, the Criminal Procedure Code contemplates the remedies in such situation. The petitioner ought to have availed those remedies instead of invoking section 482 CRPC by filing the present petition. Therefore, no interference is required in the instant case. Accordingly, the petition is disposed of. You'll get it, no harm.
My lord. Deeply agree.
Item 5.
Yes.
My lord, sorry,
Yes.
some little bit of late. Item number 3, your
3.
lordship passed over.
Okay, 3. Let us call 3 now.
Item 3.
Yes.
May I please, your lordship?
Yes.
The petitioner before my lord is facing trial for commission of offences punishable on section 307 of the Indian Penal Code and 25 and 27 of the Arms Act. Why I filed this application? Most of the witnesses were examined before the trial court, and including the injured, none of them implicated the petitioner in any manner. Some formal witnesses are yet to be examined. At this juncture, I filed that the continuance of the criminal proceeding is nothing but further abuse of the process. So I seek the intervention of this honorable court to quash that proceeding in view of the evidence which has been collected so far.
You will be acquitted. Nobody has said you will be acquitted. Why do you think? It's a honorably acquitted.
Your lordship is right on that point.
Invite that acquittal honorably, so that that's a better way of
Your lordship is absolutely right on that point. Why I am filing this application nowadays, what I noticed that for some of the official witnesses, the matter is being lingered. That is
when the
another-
FIR was registered. The
Correct.
FIR was of which year?
Good morning.
2016.
16,
No.
2016.
16. What best we could do is, I'll not interfere, but I'll just direct the trial court to
Yes,
expedite
yes,
it.
yes,
That's a fair thing. Because see, unnecessary,
My lord.
nothing has come on record. So let it be
Rather, my lord, senior,
honorably acquitted.
my lord, senior will get featured there in trial.
That is a secret dealing. You
I
can't.
know, my lord.
With that objection,
I'll dispose it. Have expedite it. I'll not indicate the timeline also. Expedite as early as possible.
Yes, yes.
I'll record your statement that see on the yes, you are for the accused. How many accused are there?
Only one accused.
You are the accused, huh? Only one accused.
Man,
The petitioner is an accused. Petitioner is the accused in the FIR number so and so. So and so. After the charge sheet was laid down by the investigating agency, the trial has begun way back in the year 2000. Trial कब began? Trial कब आरंभ हुआ?
four, again?
Trial आरंभ कब हुआ? Charge के frame वाला.
Charge के बाद exactly.
Roughly 2017 or whatever.
Evidence was recorded for commencing from 11th July 2022.
Trial might have begun in 2020. Trial might have
Your
begun.
lordship may say that in the mean period, evidence has been recorded.
Trial began since long, and there are as many as how many witnesses per examined? Huh?
12.
There are as many as 12 witnesses have already been examined.
No.
Total 12 witnesses.
Out of total 12 witnesses,
4 witnesses.
4 witnesses,
Including the injured.
4 witnesses, including the injured witness, has been examined. Then senior counsel, Mr. Mahapatra, submits that none of the witnesses is implicated the petitioner. Therefore, no case is made out against his client. Also, at this juncture, he has invoked Section 482 CRPC and 6 indulgence of this court. Indulgence of this court. Also, I am afraid that at this stage, the court, by invoking Section 482 CRPC, to curtail the trial. However, having taken into consideration the submission made by the learned senior counsel at the bar and perusing the evidence placed before this court feels it appropriate to expedite the trial and accordingly direct the trial court to conclude the trial as early as possible, preferably within 6 months from today. Accordingly, this petition is disposed. Yes.
Item 5.
Yes. Withdraw. Dismiss as withdraw. 6.
Item 6.
Please, Lordship, madam. In this application, the petitioner seeks for quashing of criminal proceeding, my lord, on the ground of a compromise, my lord.
Offense?
Offense, my lord, 341, 323, 354, 354A and 10 of POCSO Act, my lord.
POCSO?
my lord. One judgment is there, my lord. Today I have gone through that judgment, my lord. Let it come next week, I will satisfy your lordship, my lord. Allahabad High Court, what's the criminal proceeding, my lord? On the,
Also will be a problem for you.
my lord. The ground of compromise, my lord.
What is the age of the accused?
Age of the accused 16. That is totally a false case, my lord. What happened, my lord? The victim is 17 years. He has a law
Whether
of
it is false or not, we are not going to examine in this. But if there is a settlement, the boy is also 16.
my lord.
Girl must be
18 now.
Girl is
18.
acha.
He has a law of affairs. She has a law of helper.
That's right, but the technically you have committed
My
the
lord.
offense. That's the whole difficulty.
And all the inmates, my lord, have not supported the statement of the victim, my lord.
That's a different
Yes,
story.
my
You will
lord.
be acquitted.
My
That's
lord.
a different story.
Let
What
it
is the
come.
stage of the trial?
State charge sheet has been filed, my lord.
Only charge sheet.
My lord, cognizance has been taken and
Why don't we examine the victim and get
let
an
it
acquittal?
come next week. I will satisfy the lordship, my lord.
That's right. You
My
will
lord.
take the time, but better for you is to get
My
the victim examined and get an acquittal. Unnecessary. Why to invite observation from this court
Next week, my lord.
next week?
My lord.
You come with some judgment.
My lord.
We can eight will do or little more time.
9, my lord. 9.
Item 7.
Pass over, my lord.
Pass
Kindly pass.
Item 8.
Here I have challenged the order. By the Honorable Court, my lord, wherein he has rejected my application to call for one OPD register, outdoor patient register, my lord, which was allegedly of the concerned injured, PW6, but not seized by the police, my lord. And as my lord knows, my lord, this particular aspect, as in the case on the 307, and injury report is a must. And in the output, my lord, when the injured was taken to the SDH, Sub-Divisional Hospital, Anandpur, wherein he has been examined as PW6, wherein he has been treated, and thereafter, after preliminary treatment, he has been referred, my lord. So this particular document, which is very much essential, my lord, that particular fact has not been seized by the prosecution.
Essential for whom?
For both the matter, for the prosecution.
If they choose is not, that's not essential for them, that they will face the peril of it.
No, my humble submission, my lord, when they have not seized it during course of investigation, and after their examination of all the prosecution witnesses, my lord, these things has also, although I have put it to the concerned IO, the IO has also seized, I have also admitted that I have not seized the particular OPD document. So that's why I filed application with the concerned court below to call for that outdoor patient register, my lord, to establish that in fact whether the particular part, because as for the prosecution case, he was allegedly assaulted by the petitioner. But in fact, when the output is a vehicular accident. So to establish that whether it's a vehicular accident or because of the assault he has sustained, that particular document is very much essential. That's why I have filed application with the concerned court below to call for that outdoor patient register matter. It was rejected by the court below.
How many witnesses have already been examined?
No, they have completed.
If they have completed, then you lead your defense.
No, yes, in defense, after completion of the evidence,
313 is over.
Yes, there are defense.
Nothing is placed. Whether just see, you have not filed the application also.
No, I have filed
except
the
the order.
I have filed the
16/5/23 it was rejected, man. 16/5/23.
And
now it is coming, my lord.
At this stage, can I appreciate? At this stage of defense, only I can.
You are right.
Yes. So at this stage of defense, only I have filed, my lord.
But let us see 313. If 313 statements are there, then we will see if the prosecution is not relying upon something, and you will eventually get benefit out of it.
But he can file the defense, cite the defense witness, my lord. By the time he produced that and executed the same, my lord. That is open to him.
It is a document of the concerned prosecution, my lord. It's a document which I cannot produce with the concerned court below directly. So that's why, my lord, when it is available, public document, my lord, I have filed application with the concerned court below to call for that particular document for the purpose of adducing my defense, because that is a document which will prove that whether it's because of vehicular accident or because of any assault. That's why my life.
As the evidence came against you.
So assault part they have said. Prosecution has adduced the evidence to this extent that because of the assault.
Your defense is it is a.
Yes, no, mine is not my defense. It is very much available in the outdoor patient register, because my lord knows the column the doctor has to mention as per the injured, he has sustained the injury because of this and that. And the IO has also said, I have specifically said, the IO has also said that that particular document he has not seized. That particular aberment I have also taken in para 6
Well,
ballot.
where is the IO statement? There is, I was wondering, there is, except this order by which it is rejected, even the application is not placed on record. So how will I know? You may be correct also, but I need to know all these things. I'll simply issue notice, let us see. You place everything on record. Unless I see 313 statement and what is the IO says, whether you have confronted IO with that
I have,
or not, all these
then-
things has to be seen.
The mallet may keep it off day after tomorrow.
You please
Yes,
place
I-
it on record. Shall I issue notice, right?
No purpose will be solved, because if I found that I have,
He may assist also.
no, yes.
Issue notice and so and so appears, so notice and put it on when 9, 10th, what do you want? 9th.
Mallet may keep it, mallet notice, it will take some time. Next week, any day.
Simply,
You tell me which date. 9th?
only 9.
You also just check it up.
Yesterday,
Notice we have issued notice. You just check it up. Meanwhile, he'll file.
Yes, I'll file.
If it is necessary, we'll dispose it up.
Stay up further proceeding.
But if what further proceeding? It
No.
defense evidence you.
Yes. If it will close the defense witness, then nothing will be left, mallet.
No, I don't think they will close. It is pending here. How I will open it. Let them close. We will open it.
they can file petition there.
If I allow it, it has to be opened.
No, that.
Don't worry. No, nothing will happen.
Usually.
482. We can
yes.
open it.
No. Usually while admitting or issuing notice.
No, I'm just simply issuing notice because there is nothing on record. I couldn't see anything on record. So let it.
Yesterday,
Pardon me, item 7, madam. Item 7.
9th.
Pass over.
I have taken on 9th.
9th.
Sir, I may be
Pass over.
pardoned.
I'll just call.
My lord, I may be pardoned for interrupting.
Yes.
My lord, I may be pardoned because the code was something different. That is why I couldn't just place the matter. I have small submission that one CRLM.
In which matter, sir?
Sir, in CRLMC 4724.
No, item number?
No, sir, is not item number. I just wanted to mention. So kindly excuse me. The fourth-
Mentioning, could it be done at 2 o'clock?
Yes,
I
my
will
lord.
reassemble 2 o'clock.
Okay, my lord. Okay, my lord.
Item 9.
May I plead, Your Lordship? I have come before this honorable court for an innocuous prayer that the matter is pending before the learned vigilance court, special judge vigilance court from the year 2009. The FIR has been registered in the year 2009 and charge sheet has been filed in the year 2012. Lordship will find the order sheet that is at Annex 3, page number 26.
20, page number 26.
It starts from page
Okay.
number 26,
Okay.
my lord.
Yes.
For PW6, they have taken almost 2 years' time.
How many adjournment you have sought?
I have not sought any adjournment. For PW6 examination, it has been adjourned. I'm for the accused, my lord.
This is the entire order sheet.
The orders.
Part of the order sheet.
My lord, from PW6, I have enclosed the order 6 from 8/3/2022.
2009 is the FIR, huh? 2012 is the
Charge sheet, my lord.
Lordship.
And the charge was also
Very-
framed on.
How much? How much time?
15 witnesses are there, prosecution witnesses.
50. 1/5.
1/5.
How many you have examined?
5.
So far as his the statement of the petitioner is concerned, that is the 6.
5, my lord.
5, 6 is our.
6 already you have taken 2 years.
But 6 has not.
How
been-
much time will you take to?
Lordship,
conclude?
direct for 6 months.
As Lordship, 3 months or if possible 3-4 months, because his pension is at stake. The government has not sanctioned the pension, the final pension, because of this vigilance case.
When he retired?
He's been retired from the year 2014, my lord. As per my instruction, 14.
14. Okay, let us make it 5 months.
Yes.
Not
My-
same 6 and 3.
My-
Let us make it 5. But I'll tell you, I'll write something on this to say that if the trial court generally what happens is it is targeted. The trial court is not able to conclude for any reason. The trial court has to intimate this court.
And they move. Usually they move this court for seeking a further
extension,
adjournment. My lord, my lord.
I don't know whether they do.
And if direction is to a trial court, then they are moving. Usually.
No. Okay. We'll do it for 5
No,
months.
much obliged.
5 months, huh?
Right.
Please don't say.
Deep leverage.
Dispose of this. Dispose of.
Item 10.
Remove the word.
My lord, item number 10, may I be permitted to appear through VC, my lord? Item number 10. This is a Belgium. May I please, my lord? This is a Belgium matter, my lord.
What? Sorry?
This is a Belgium matter, my lord. NBW
What?
was issued, subsequently 82-83 process was issued.
82-83 has been done.
Yes, my lord.
Then
What happened is, my lord, at flag A, earlier this petitioner had approached this Honorable High Court, wherein this Honorable Court was pleased to grant the petitioner to surrender before the learned court below and move his bill application. Pursuant to that order, the petitioner couldn't able to surrender as because the petitioner went to some other village for work and he couldn't be contacted, my lord. And in the meantime, COVID came. And for that reason, he is before this Honorable Court once again to give him a chance to surrender, my lord.
where is that last order? Last order is at page 11.
Last final order is at page 12, my lord. Page 11 is the order of issuance of NBW. And page 12 for 82-83, my lord.
Yes. Accused is absent on perusal of the record. It reveals that NBW was issued against the accused on such day, but the same was not yet executed. Hence, the issue against the accused as a production of the accused. The process issue. Hence, the issue demanded the execution. So, what do you want now? Go and surrender.
My lord, if permits,
Earlier occasion also this Honorable pass order, this Honorable pass
Who
order.
stops you to surrender?
is with due respect, I will if my lord allows me to surrender one more time.
You don't need my permission. Already NBW has been issued against you. Go and surrender. It's simple as that.
Surrender if he was on bail, my lord. Earlier he was on bail. Released by-
Surrender and apply for bail.
if my lord gave me a chance to move my bail application
So
and
this is a bail application in disguise then.
I humbly bow down, my
You
lord.
surrender because there is an NBW. You surrender. You tell me when are you going to surrender?
My
I'll
lord,
record it and dispose it out.
yes, my lord.
And thereafter you apply for bail.
My lord, may kindly he will be kept inside. For that reason, my lord, may kindly have a glance. Please to have a glance at flag A, my lord. The earlier order. He was earlier
Where is
granted
flag A?
bail. Earlier,
Okay, you will get benefit out of that. Once you surrender, then again you apply for bail.
my lord, may at flag A, your lordships.
See, 2017.
Yes, my lord.
You surrender and ask for regular bail. You are taking everything, it's granted.
My lord, I humbly
It's on 15 FIR.
that
You got the indulgence of the court, got the bail. Thereafter, you jumped the bail.
I bow down, my lord.
And High Court gave you indulgence once. Again, you are coming the same way.
I bow down, my lord, but he was my humbly submit, my lord. He was not unable to be contacted because he was walking outside in a remote area. And now
Unable to contact. You couldn't contact.
My lord, he was unable to be
He
contacted.
has instructed he is supposed to contact.
I bow down to that effect, my lord.
So you surrender and ask for regular bail, you will get it on merits. What is the offense?
376, my lord, offense is under section 450 and 376 2L.
Okay, I'll pass appropriate order. I'll pass appropriate order.
Obliged.
Protecting you.
Obliged, my lord, deeply obliged.
You do it at 9, 10. Dispute.
Disposal.
Item 11.
My lord, disposal.
Yes.
But in 11 and 16, on behalf of Mr. Sadangi, is requested next week, my lord. See,
Next week.
11 and 16. my lord.
11, 16. Next week. 10, 11, anytime. 11? 11 will do. 11.
Item 12.
May clear losses. In this prayer, my lord, petitioner FIR is under annexure 14, my lord.
Huh?
Petitioner FIR is under annexure 14, my lord.
FIR is
Annexure 14, my lord.
annexure 14.
My lord.
14.
14, 1-4, my lord.
Where?
Unless that, my lord, due to
1 minute, 1 minute. This is item, which item?
12, my lord.
12.
1 minute.
An allegation, my lord.
There are four annexure only.
1-4, my lord. 12-13. Serial number 1012, my lord.
No, there are 4 annexure. Where is 14 annexure?
14 phase, my lord.
Phase 14. Phase 14. Annexure 1. Okay.
Allegation, my lord, is
What exactly you want? Let us see. Watching of the
my lord,
proceeding.
lastly, my innocuous pair is, my lord, your lordship kindly targeted this city case number, my lord. Can I targeted the city case number 128 to 21, my lord?
I couldn't follow you.
Your lordship kindly targeted the city case number.
Why target when the FIR?
FIR, my lord.
21.
21.
21 FIR you target. You will march over the other accused person who are waiting. Merely because you could afford to come to this court.
Petitioner is a teacher, my lord. Only allegation, my lord, produce fake OTT certificate, my lord. During pendency of the city case number, petitioner could not get his salary, my lord. Till 21, my lord.
This is a different remedy. Have you produced the fake certificate or not? That
No, I have not produced any fake certificate, my lord.
You lost the job or continuing the job?
Continuing job, my lord.
Continuing job.
My lord.
You are lucky then. You are lucky. FIR is
21, my lord. 21, 12, 21, my lord.
You are asking for the quashing of the FIR.
My lord.
But at the same time, you want
My lord.
जो फर्स्ट आइटम में जो ऑर्डर किया था सेम ऑर्डर करके फर्स्ट आइटम कर सेम ऑर्डर करके डिस्पोज अप कर ऑब्जर्वेशन करके डिस्पोज ठीक
13 also same manner city case no different
which one 13 same first order क्वेश्चन में constitutional right so it's not informant it is an accused लाइट चेंज करना है थोड़ा ठीक है
item 14
pen drive my pen drive is correct no don't 14 also same disposal.
Only 12 and 13.
12, 13 disposal.
Item 14.
14.
Please, permitted to withdraw, my lord. File a better application.
You want to withdraw?
Yes, ma'am.
Okay. Withdraw. Withdraw.
Item 15.
Pass out.
Copies are not something. That's what happens.
Pass out.
Item 17.
Yes. 17. You are appearing?
Minor.
17.
I'm for the state.
State. Nobody there. Pass out.
Item 18.
Pass out only.
Pass out.
Yes.
Let us see second call.
Yes.
18.
Item 18.
Yes.
17 is there. 17 is there.
17 passed over.
Pass out.
Nobody there. 18.
Yes. 18 my lord.
That the FIR under Annexure 1, page 11 has been filed. My lord, relating to a civil dispute in which, my lord, the complainant, the informant and the family members forcibly occupied the land in question, and they are running a country liquor in there. My lord, when the 107 and 144 order was there, and it has not been promulgated by Annexure 2, this is the report of the Tahsildar. My lord, they are not allowed, page 16. They are not allowed the authorities, my lord, to promulgate that order 144.
144 order. Okay.
My lord, they have filed FIR, false FIR, my lord, making allegations against the informant. My lord, in which, my lord, the cognizance has been taken against the accused person.
You are challenging the cognizance
My
order.
lord.
What is the allegation against you?
Allegation is that, my lord, when we reached there and
Read the allegation.
My lord. The page 13 is the
Yes.
FIR.
Read it.
Mu Padi Bhavani Pita Padi Prasad Basastana Swanso Thana Adhinkarika Pakhare ମୋର ଏତାଲା ଦେଉଛି କି ଗତ 27/12/2021 ଦିନ
Before my lord, before my lord going to the merits of the case, when my friend is filing this application challenging the order of cognizance, your lordship may kindly turn to page 24. Charge has already been framed and trial is about to be commenced, and the date has been fixed to 2/5/2023. How cognizance will be challenged here?
Well, it has not been started. The trial has not been started.
You know, lost the train in the time to challenge it. Now, charge has been framed.
My lord. In page 24, order dated 12/4/2023.
How many witnesses are cited?
Not
My lord, the case is fixed to 2/5/2023 and 3/5/2023 for hearing.
Not a single witness.
And someone has missed.
No, the charge is
framed.
when the charge was framed?
Charge framed on 12/4/2023.
Oh, April only.
Yes.
How many witnesses you have cited the prosecution?
No, but that document is not there with me because my friend has annexed the impugned order. From that I found it.
Where is that?
Page 24, your lordship may kindly
24. I am on 24. Read it.
My lord,
Read 23. Heard. Learned counsel. Next. Heard the submission advance on 23.
Yes.
Heard the submission advance on behalf of the prosecution.
Yes, prosecution represented by the learned special public prosecutor and the learned counsel for the accused person from joint reading of the affair and other documents available in the case record. Prima facie found that the accused person have committed the offence punishable under section 147, 341, 323, 354, 506, 149 of IPC due to section 31 FRS 32 VA of SC and ST PA Act, and such as charges of offences under section 147 so and so are framed against the accused persons, namely Dullada Srinivas and Dasari Aporao. Charges under section 147, 341, 323, 506, 354, 149 of IPC is framed against the accused persons, namely Nando Pidisika.
So charge and so you framed
Mine.
against the accused persons, namely so.
Mine.
So.
Mine.
The contents of the charge are read over and explained to the accused persons in presence of their counsels in the language which the accused person understands. On being asked whether the accused persons plead guilty, the charges read out and they explain to them, and they plead not guilty and they claim to be tried.
Mine.
Defense does not admit to the documents while on the prosecution. And the case is fixed to what happened on 2nd May and 3rd May for hearing.
The witnesses which were summoned has not appeared, my lord. The trial has not started. Not a single witness has been examined.
So now the fact remains is how many accused here you are? D. Srinivas. Charge against D. Srinivas is framed?
Yes, my lord, the first.
What are the charges against him?
These are the charges on Dudula Srinivas. Page 24. Dudula Srinivas and Dasari Apparao. The Dudula Srinivas is the petitioner before your lordship.
No,
That-
I don't think I can quash the cognizance order. Now charge has been framed and you face it. Because see, there are many other accused persons. The moment there is opening a Pandora's box, he enter into a merits at this stage. That too after framing of charges.
And the fact remains, my lord, your lordship may annexure 2 page 16. This is the
fact remains is there was 144 proceeding also.
My lord.
If you started saying that it is a civil proceeding, saying the civil proceeding, there is some problem. Therefore, 144 proceedings and 145 proceedings were initiated
against the
whatever. But there is some kind of
my lord.
there that so therefore the very fact that it is pure and civil case, that nobody is going to believe. And after thereafter your charges are just see the charges SC, ST and everything is there. Better you face trial, and I will make some observation for the expeditious disposal. Okay. Since you have come. Okay. So give it to me. Okay.
Disposal.
Disposal.
Yes.
Because see, I'll tell you, expeditious trial is otherwise also there entitled. So that observation we will make at least here at least.
Right.
Okay. I'll not target it. I'm not going to target it.
Just expedition.
Obviously they are entitled.
Yes.
Constitutionally they are entitled.
Right.
Very. Yes.
I mean, pardon, item 7 just pass over.
Yes. Yes, sir.
Due to leaf problem, I have
17.
May I please, Your Lordship? The present petitioner, assailing the order dated 30th/6/2023.
Annex 2.
Annex 2, page 36.
What
This
is this
record is
order?
put up today. Although I has submitted charge sheet by its charge sheet number 88 dated 30th/6/2023 under section so and so in connection with so and so PS person so and so against the present petitioner.
You are Mr.
I am Mr. Pramod Kumar Sahu.
Pramod Kumar Sahu. Okay.
Then, Your Lordship,
how many accused are there?
3 persons they have been charge sheeted most probably. I have annexed the charge sheet.
Okay.
Prior to coming to this case, my lord, Your Lordship may kindly see the FIR annexure 1, page 11.
Now, what is this order? Let us see. What you are challenging this. There is the same and Professor case is
Accused persons, namely 1, Pramod Kumar Sahu, so and so, so and so.
It is a cognizance order.
Cognizance order.
Okay.
Why, my lord, I am challenging the cognizance order with concerns and everything taking into consideration, my lord, the entirety. For the investigating agency done and submitted the charge sheet. First of all, my lord, I mean to say before Your Lordship, from the bare reading of the entirety charge sheet, including the investigation report, I cannot just cite it before this on court case diary is prerogative of the prosecution. The statement, the charge sheet, the FIR. If it will be taken into consideration together, prima facie there is no material against the present petitioner to connect him in the alleged crime.
What is the allegation?
Then Your Lordship turn to page 6 of page 11 of my brief.
11.
That is the FIR.
Yes, I am on that.
Running page is 13.
I will read column 12. Read column 12.
So and so.
Column 12, first information contents. Read it.
On dated 18/10, dated, that is on. On 18/10/2022, at about 12:30 p.m., Sri Somyaranjan Pati, SI Police, K. Nogwa PS, appeared and lodged at condition and lodged this report to the effect that today, that is on 18/10/2022 at 12:30 a.m. as per the direction of the IAC, that is by CC command certificate number so and so, dated so and so, and GD number 15 dated 18/10/2022. He along with ASI so and so police personnel police were performing the night patrolling duty at PS Bolero vehicle bearing registration number so and so being driven by AD Pitambar Behradali at about 5:30 p.m. while patrolling near Sibo Temple of Purana Nuagaon area. On seeing police vehicle, suddenly one white collar car turned around and proceeded towards Daringbadi Chowk. On suspect of some wrongdoing, they immediately chased and apprehended the white collar Swift Desire car, white so and so near Kamangi Chowk, but driver fled away from the spot. As the suspicion grew, they verified the car dicky and found white collar jerry bag, that is bag from which acute smell of ganja is coming out. Immediately intimated the IIC K Nuagaon through phone to comply with the procedure of seizure in compliance to the section 50 subclass 2 of NDPS Act. He sent written intimation along with a requisition for a prayer to the SDM for deputation of executive magistrate through ASI K Barik and directed him to bring his personal laptop, printer, battery, brass seal, packings, stitching materials, one electric weighing machine, and required form and formats. By the time police staff guided the car, he searched for the two numbers of independent witnesses from the locality. He found two persons, namely so and so, of so and so. On asking, they both agreed to act as an independent witnesses in this case. Then all of us, including the independent witnesses, waited there till the arrival of the executive magistrate and weighing man to the spot at 7:30 a.m. ASI
come to page 13.
Page 13. That is the content of the FIR.
Yes. Come thereafter from the dicky. Page 13. Thereafter from the dicky. Read from there.
Second paragraph, page 13.
Second paragraph. Thereafter from the dicky of the car bearing number so and so, one jerry bag was found. On verification of the jerry bag, we could be able to confirm that the pungent smell is coming out of the bag, and taking that the bag contained contraband articles, ganja, so and so. That paragraph will clarify. You are the driver. You fled away from the place.
No, that is the whole thing. Then your lordship may kindly see the 161 statement of the witnesses.
Who are you then, according to you?
I am the owner of the vehicle. I am fairly conceding this for your lordship. The person, those who are driving the vehicle, on the relay.
How the vehicle that is body 02 of BG 758, you are the owner. How has it gone to the hands of the accused persons?
Because they are the driver. One person is the driving my vehicle. That is
these all are matter of trial.
No,
these are all matter of trial. Today you can't presume everything.
Go to that extent, my lord. We have to believe that this thing is to
you. I'll tell you, you are entitled for bail.
No, I have already been granted bail.
You should be happy with that. And pay the trial.
Because, my lord, because your lordship knows that, conducted many cases.
You are the owner of the vehicle. The vehicle was apprehended by the police. Two accused persons were found possessed with ganja.
That two accused persons, my lord, they are.
You admit that the vehicle is yours.
No. I was not there. One is Tumka.
You may not be there. Conscious possession is not there. Therefore, you got the bail.
Right. Now, all the poor persons, they have been granted.
Obviously, I am not on that. We might have got it.
This honorable court come to a.
What is the quantity?
24 kg.
24 kg.
750 grams.
Otherwise, also you will be acquitted.
And
no interference.
Subject
because why, my lord, I am saying so before your lordship. One Tumuka Malik, Amar Naik. On the relevant day, the villagers, they have found that while the investigating agency interrogated the villagers, while they were chased out 2 persons.
What is the stage of time?
But the NBW issued my learned senior has annexed 37.
That he has been granted there.
Got a minute, 1 minute. Your lordship may kindly turn to page 37. Page 37. 37.
37, okay.
37.
Order C.
But at the cognizance of the offense, punishable under section 20B to C of NDPS Act is taken. Lordship got it.
You are reading 37?
37, page 37. In pen written, taken. Your lordship, from that place I am reading.
Yes.
In pen taken. Accused person are on bail. Wide order dated ATK 13/4/2023. NBWA has been issued against the accused person, namely Pramod Kumar Sahu, the present petitioner. This is the This is the stage of NB. Now, my lord, your lordship may kindly see. My subject to correction of my senior, one anticipatory bail application has been filed before this honorable court. Then one 482 application also filed prior to these cases before this honorable court in CRMC number 2578 of 2020 of this petitioner, particular petitioner.
Seeking what?
I don't know, he used to say.
What was that?
He used to say
482 petition.
That is for quashing of FIR.
You lost there. Thereafter, cognizance was taken. Bail was granted. You thereafter jumped the bail.
No.
Got NBW.
No.
And now you are challenging cognizance.
No, my lord. That is wrong submission. I am clarifying. Please.
But you filed a 482 earlier.
My lord.
Challenging quashing of FIR.
No, quashing of FIR.
That you lost.
No.
Where is that order?
Oh, I have withdrawn that. Because I have withdrawn. I am submitting step by step.
At what stage things are withdrawn, you know that. Now also you withdraw. That's better for you.
Order sheet after that, he has been apprehended. He has been lost to custody. Thereafter, the bail application has been filed. He has been granted. Now the order in question of the second part of the order in question goes. That NBW.
It doesn't go, sir. It remains. The conduct of the accused during the trial remains on the record.
No, that shows that he has been surrendered, applied for bail, that has been turned out by the law and court below, and applied for bail before this honorable court going to the entirety granted bail. Then second part of the order is goes, not remains.
Thereafter NBW.
No NBW, nothing else.
This order says.
After that, he has been surrendered. Bail After that, he has voluntarily surrendered before the portfolio, applied for bail, and the law and court below, your lordship knows that the law and court below taking into consideration 37 is a bar. Usually they have passed the order. Bail application is rejected. Thereafter, he has filed the application for bail before this honorable court. This honorable court, after going through the entirety, granted bail. Then second part of the order remains goes because no NBW is there. He is regularly appearing before the court below, and till today, that case is pending before the law and court below. My humble submission before lordship, if we will go to the law and the statutory provision of law.
Where have you disclosed that you had filed earlier 482 petition?
My lord, that is in my cost item. The matter out of which this CRMC of the petitioner arises was before this honorable court in ABLPL number 4.
That is 2578.
Yes, I have disclosed.
You filed that petition. I would just want to see that.
My lord?
Copy of the petition you just filed.
Copy of the petition.
And the order also. Well, you have to see that.
Because a person is to be dragged to the face the criminal consequence. That is not the intention of the criminal jurisprudence, my lord. Because I have the owner of the vehicle. I am giving an example. I've left in the gym of my driver. After got out from that cab, I was attending this.
This is your story. They will have a different story.
No,
they'll say that it is you who has employed these two people to get it transferred. That may be their story.
That thing I am.
It has to be both the story has to be tested in the trial.
Trial.
You may be correct. You will get acquitted.
If your lordship view is I am going to be acquitted, why person will be trapped to face the criminal consequence? Where there is prima facie, there is no material, neither in evidence nor anything has been.
Evidence is there because you are the driver of the vehicle.
No, I am not.
Owner of the
Sorry, owner of the vehicle.
Owner of the vehicle. Even accepting for a moment, I am
and
owner of the vehicle.
You have accepted that position.
My lord, to that extent, I am conceding to that extent.
You are an accused.
Where is the material
what
that
to do?
I have the culpability and the criminal intention to direct my driver to commit such crime? Where is that matter? This is the duty of the investigating agency. That is not the duty of mine. Because I cannot take that plea during course of investigation. After submission of charge sheet, my lord, I am submitting before a lordship. Because this is the duty of the cast duty upon the investigating agency to bring out the real true state of affairs.
Car was apprehended where? In Nuagaon.
My lord, I am belonging to the Khordha district.
How the car has gone there?
Because my driver has employed, he has taken that car for higher basics. But unfortunately, I came to know that this has been.
There are many stories in between.
Is your driver?
I'm ଶିଖିଛି ଆପଣଙ୍କ ଥରୁ ଶିଖିଛି ଆପଣ ଆଳକୁ ଦେଖିଛି କହୁଛି ସେଇଟା ଆଉ ବାହାର କିଛି କହୁଛି
ଆପଣ ନୂଆ ନୂଆ story କହୁଛନ୍ତି
Yes, you are not sure.
Driver तापरे भी कोई higher basis रे.
higher basis.
ଆଗରୁ
Now,
ଥିଲା
how will you test it? In the trial only it can be tested,
ନାଇଁ
sir.
ଟ୍ରାଏଲ ତ ମୋ ନାଁରେ କିଛି ଏଭିଡେନ୍ସ ଆସିବନି ପ୍ରାଇମ୍ ଅଫିସ୍ ଦେयर ଇଜ
That's good. You will be acquitted.
ନାଇଁ ବେଲ୍ ତ ଅଛି ସବୁ ଅଛି ସିଡି ଟା ମୁଁ ଷ୍ଟେ
ନା,
ପାଇଁ ଯିବାକୁ
CD କଣ ଦରକାର? Not necessary
Right.
CD.
Stay to
CD is not at all necessary. You argue on your own
Why
point.
is-
I am
I-
here
I-
to argue. I am
I-
here to argue.
Where is the material your lordship may can
My first point, my lord,
It's
why
very
the
difficult.
past CRMC application
wait,
withdrawn?
wait a minute ମୋର ଗୋଟେ ଜିନିଷ your lordship knows that supposing I am filing the application prior to my case one case my friend has argued your lordship knows that the judgment of the apex court even though at the time of framing of charge cognizance can be challenged that is the view of the apex if cognizance goes charge goes automatically supposing the view of this honorable court and source of apex court I am challenging the FIR story in view of the guidelines of the state of Haryana Bhajanlal. Prior to that is the Sindhia versus Sindhia, 78 or 79 Supreme Court. The guidelines.
Where do you follow in the Bhajanlal?
State of Haryana versus Bhajanlal.
That's where that exempts.
Then my lord, 8 guidelines which has been.
Where in which guideline you fall?
I mean to say, prima facie there is no material. A malicious proceeding has been initiated against me. This is the duty of the investigating agency to brought out the entire materials because
the trial court says that prima facie material is there. Cognizance has been taken,
usual practice,
and I am of the same view.
Because this is the usual practice, your lordship once upon a time.
Anyway, you file that 482. Let us see why you have withdrawn.
Yes.
Let us see.
Yes.
If it is a copy paste thing, then I'll dismiss. It must be copy paste thing.
ନାଇଁ କପି ପେଷ୍ଟ ଆସିବ
Thank you.
ସେଟା ଏଫଆଇଆର କୁ ଆସିକି ଆପଣଙ୍କ
ସେ ପ୍ରେଟା ଚେଞ୍ଜ ହେଇଥିବ ବାକି ସବୁ ସେମ୍ ଥିବେ
because
ଆପଣ ଫାଇଲ କରନ୍ତୁ
I cannot open in the court
ଦେଖିଦବା ଫାଇଲ କରନ୍ତୁ କରି
8 ରେଟ୍ କେ ମୋର ରହିବି ଡିଫିକଲ୍ଟ ରେ 9 or 10
ଫାଇଲ କରିଦିଅନ୍ତୁ
ନାଇଁ ସେଇଟାକୁ ବି ରେକର୍ଡ ଟା ମଗେଇଦେଲେ ବି ସୁବିଧା ହୁଅନ୍ତା କପିଟା ଆଣିଲେ
record Sambandhi record of what is that?
CLMC 2578 of 2023. Disposed upon 27/6/2023.
The request of land counsel for the petitioner, the matter is adjourned to 10th. File of CLMC कितने था?
2578.
2578. Page 2 of my brief.
ठीक है. आप फाइल करो तो नहीं देखी दो.
हाँ सही था बस.
You have a difficult case, but still you can try.
Difficulty. While your lordship is there, difficulty will be so easier than
that is why it's difficult.
My brain may not be known.
We'll see.
I know.
We'll see that.
Okay. ଆମେ ଯାହା ଜାଣୁଛୁ ଆପଣ ମାନଙ୍କ ପାଖରୁ
It's a learning process, sir. It's a learning process.
Obliged.
Yes. Item 19.
Madam, I may pardon, my lord. I am from VC Mirror. Item 15 on the number item. And my lord,
we are on 19.
Technical mistake.
Don't allow.
I could not able to.
Wait. It is passed over. We'll call. Yes, 19.
Here the petitions today, since today. Here the village dispute because the village dispute. While the petitioner go to the village for confirming the funeral rights, and some incident has been happened. Is it because of that the FIR has been lost? After that matter has been settled.
Use the mic.
After that matter has been settled, I have given the annexer 2 matter, the compromise picture. I pray for pursuing of criminal proceeding. Once a matter is settled among the parties matter.
What is the offense?
Offense, 294, 323, 341. 354, 452, 506.
380.
380.
Compoundable. Which are the offenses compoundable? Which are not compoundable?
Maybe compoundable.
Both the offenses are not compoundable.
If matter has been settled, there is no bar. 320 is not.
Yes, sir. Once they have compromised the dispute, then let them both the party to appeal.
Who is the informant?
Informant is noticed.
Oh, you have not implemented.
I have implemented.
Right.
Pushpa Pradhan.
Yes, Pushpa Pradhan.
326 is there? 326, 320, anything? Bodily injured?
323.
354 is there?
351.
354, okay. 354. What she is Pushpa?
Pushpa Pradhan.
Pushpa Pradhan.
Okay. Notice. ଆପଣ ସେଭ୍ କରନ୍ତୁ ନା number 2 କୁ ନେଇ ଆସନ୍ତୁ.
By registered post,
No, no. They see he says that settle, then you can bring her.
Yes, sir.
Here.
Yes.
When? Tomorrow?
Tomorrow and
Bring her tomorrow, we'll squash it.
Yes.
Why to waste time? You have settled?
settle
This lady is there with you, the complainant.
No,
You can very well bring her. Why should the court will issue notice?
Yes. I am here, but he is the village. What village?
So you bring, I'll no notice. I'll not. Why should I court will summon? You have settled.
Yes,
You
yes.
bring her.
Well, you not see another 2 cases that both are there come. Another 2 cases there.
Item number?
Man, item now is listed.
How many?
Case is out of case. 2 cases are filed against us. Another 2 cases against him. Therefore,
ଆପଣ କୁହନ୍ତୁ, you bring everybody.
Yes.
I'll record their state and I'll record the statement, quash everything. But I am not going to summon anyone.
No, date will fix. All cases will be listed.
Give the numbers. Give the numbers and ଆପଣ କୁହନ୍ତୁ, date କୁହନ୍ତୁ.
Number ଗୁଡ଼ା ଦେଇଦିଅ.
3425, 3426.
Different FIR, cross FIR. One IO.
2 FIR against us, 2 FIR against him.
IO is one. Same police station.
Same police station.
ଆପଣ IO କୁ ଡାକି ଦେଇଥିବେ, ଆଇଡେଣ୍ଟିଫାଇ କରିବ. ସେଇଦିନ IO କୁ ଡାକି ଦେଇଥିବେ, ଆଇଡେଣ୍ଟିଫାଇ କରିବ.
All right.
Accused ମାନଙ୍କୁ
ସେ ଡେଟା କହିଦେଲେ ମୁଁ ଡାକି ଦେବି ସେଦିନ.
ଆପଣ କୁହନ୍ତୁ, ଡେଟ୍ କୁହନ୍ତୁ.
Immediate you not seeking.
Short date ଦିଅ. 3ଟା କେସ୍ next week 8. Call the IO.
Yes.
Because IO has to identify, na?
Yes, yes.
8, all the cases number you give, all the 3 cases. If you have settled all the matters, then we'll do it. Call the IO, huh? Number would have the case. Huh? Give him also all the numbers. 8th.
Item 20.
Yes. $20. Pass over.
21. No, it was. If not, I have challenged the convenience and also the proceeding. And also see this one the FIR. Here the malad the petitioner, in fact, is in the branch manager.
The impugn order is page 21.
Page 21. Let's see. Here they filed a complaint case arising out of malad that GR case was registered. Lordship would see the page 13 is the annexure 1 is the FIR, and Lordship would see page 15.
Page
15.
15.
Here, my lord.
Yes.
The complainant malad is Srimati Pareda. But complainant name is one Srimati Pareda. But Lordship see the extract of the order. Just next paragraph after that.
Yes.
Complete petition was filed with the complainant Gauri Behra. Their complaint was mismatch.
Filed by complainant Gauri Behra.
He made a complaint mismatch. Srimati Pareda is the complainant. But the order says one of the Gauri Behra. And on the basis of which one of the FIR also was also registered. Or directed to be registered.
ଆମକୁ କୋड ଦେଇନାହାନ୍ତି ତ କିଛି?
You are challenging this order?
Yes.
Huh?
Yes, that is what I am challenging.
You are Sunil Behra.
Sunil Behra.
That may be a typo. What?
Yes, there is a typo error.
Maybe.
But there is also some material in the sense they. Yes.
What is the allegation?
Yes, my lord. That part, my lord.
Hmm.
Here, my lord, the allegation is that let's say it is a commercial transaction. Here they.
You come to page 16.
Yes. The informant, my lord, in fact, availed a loan from the petitioner's institutions, my lord. It is an IIFL Finance Limited, a pan-India business organization It is having branches all over India, and one the branch at Balugam. And this petitioner, they are the branch manager, and he is the branch manager. Her allegation that he availed the loan, and since the loan was could not paid, that was auction, and entire fact allegation that comes out of that matter. See I'm reading the relevant portion, my lord. Let's see page 18.
No, but what happened to this order 156.3?
FIR was registered.
So investigation is on.
Investigation complete, charge sheet was submitted.
Charge sheet filed.
Yes.
But you are challenging what?
I am the cognizance under the inter proceeding of challenge.
No, you are challenging.
Because after charge sheet, there will be one cognizance.
Cognizance of.
Yes.
That is the page. Okay.
Let's see the page 18.
18.
Yes. What is the allegation? Let's see. एक ही मुद्दे से मध्य प्रोडांकर घर तय करबे अर्थ आवश्यकता हेबारु बालुगा पेट्रोल पंप रेकर्ड थिबा आईएफएल फाइनेंस कंपनी रो ताकर दुईटी सुना हाट दुईटी सुना बुद्धि दुईटी पट सुनार चुरी दुईटी सुनार कान पेंडी फुल गोटे सुना चेन बंद रखी 1,83,800 टका आनितले मास मास सुनील बेहेरा मैनेजर नंबर 1 मुदला मुदे घर जे सुध बंध पट 40,000 टका आनिचंती रसीद मागिले कहूँ तुम समस्त ऑनलाइन माध्यम ऑफिस बांधि दी गत 18/5 12 घंटे समय मुझे एफएल फाइनेंस कंपनी जाई ताका बंद रखते सुनाहाना बंद.
And you are the manager of this company.
In fact, it is not true because the no branch manager never goes to collect the money. That is, they either pay to cash, they will obtain the receipt.
The fact of the matter is, IIFL Finance Company has cheated these people.
Yes.
You are the employee, you are the branch manager.
Yes.
No, cheating or not cheating or not. Here, he since did not, could not, they obey the terms and conditions of the loan agreement, and they were defaulted. After following due procedure, the NPA, after the account was declared NPA, that auction was held. He says that auction was held without my notice. That is the horrible allegation. But taking into that allegation, it is obviously commercial.
What about this finance company is still functional?
Yes, my lord.
It's functional.
Yes, it is having all over. It is not having many branches all over India, my lord.
ମୁଁ ପ୍ରତିବାଦ କରି
ମୁଁ ପ୍ରତିବାଦ କରି କହିଲେ ଆପଣ ମୋତେ ନ ଜଣାଇ ମୋତେ ନୋଟିସ ନ କରି ମୋର ସୁନା ଖଣ୍ଡ କିପରି ନିଲାମ କଲେ ମ୍ୟାନେଜର ସୁନୀଲ ବେହେରା ରାଗି ଯାଇ ତାଙ୍କ 3 ଜଣ ଅଫିସ କର୍ମଚାରୀ ଡାକି କହିଲେ
Now the plight of the complainant, you may kindly see on the other side. He has given the gold and taken loan. He has paid the loan but did not get the loan.
So what he is saying is he didn't pay the loan.
Yes, he has stated.
Defaulter, and therefore it was auction.
That is his submission. But the complainant has stated in her affair.
Hey, what is the investigation?
Yes, because only cognizance has been filed. Cognizance order, the impugned order has been filed.
Charge sheet, whether she has defaulted in the loan.
Yes, exactly.
Or
You
not.
rightly pointed out.
If defaulted or no, and it was properly auctioned and by following due process, or
even after that, even though some regulating this auction, he has a remit in elsewhere. How a criminal case will matter?
Supposing, my lord,
what the story is.
Yes.
The complainant has taken loan.
Yes.
Mortgaging the gold.
Yes.
And what apparently he says is he defaulted. Once you are defaulted, the natural consequence is the money has to that
will be auction.
Mortgage, it was auction.
Yes.
And once it is auction and money was paid back and loan is stand good, then the officers, how do you hold up the officer for criminal charges?
That is my point, my lord. But you also can say she has stated she has get loan, but she paid the installment through the petitioner, and the petitioner did not pay the amount in the finance company.
Let's just say
that is the whole fact.
Where is the charge sheet? Let us see.
FIR, my lord.
Charge sheet, just see the charge sheet. Because you filed 156.3. Court said that lost the FIR.
Yes.
FIR was lost, investigation was done, charge sheet was filed.
Both courts usually Usually they died for registration affair without taking that what is the allegation. It is my lord, it is the custom
No,
of
that
the
is the
banker.
procedure. 154 is not followed. Registration of FIR. 156 is natural consequence. You file it. Okay, now FIR is
2 months delay, my lord. 2 months delay.
Oh, those things
that
matter.
is also right.
Watching,
It is
you
arranging a
show-
complete case. No?
Now you show me the charge sheet. After investigation, what are the facts?
Yes.
Where is the charge sheet?
Let him to file the charge sheet.
Show me the charge sheet.
So I have certain documents.
FIR is reproduction of your complaint, 156 complaint.
Yes.
Thereafter, investigation has taken place. Charge sheet is filed. Charge sheet will give you the right story.
Right.
That, my lord, all these are commercial transactions.
Show me the charge sheet. Show me the charge sheet.
My lord, the authorities, the police authorities.
You
they
tell me,
not
you are
competent.
challenging the cognizance of.
Yes, ma'am.
Cognizance is taken on what? FIR or charge sheet?
That is, my lord, on the
Obviously FIR.
Oh, FIR.
Yes, obviously charge sheet.
Charge sheet.
Where is the charge sheet? I should need to see the charge sheet. Na?
Not may call for the LCR.
No, it is your 482 petition. Why should I call?
LCR
State
File the charge sheet. No. Charge sheet is it is there with you. File the charge sheet. You take the
I
time.
have
to file.
not document take some time, my lord. I have certain document.
So without filing charge sheet only, without reading charge sheet, you file
I have
challenge the cognizance.
I have perused the charge sheet, man.
File the charge sheet. It is your petition, 482 petition.
My lord,
You want the intelligence of this court, then you need to make good all the, you file the charge sheet. 1 week, Monday, Tuesday.
But some more because I have to upload the Baluga. It may take some time.
Scan करी मगे दे
लॉर्डशिप का स्टेट थ्रू द सील भलो होता सिविल सर मगे
482 की फाइल करती
मु करछि लॉर्डशिप मे रिलाय मे नॉट रिलाय ऑन माय डॉक्यूमेंट
no तो कि आपण कॉग्निजेंस ऑर्डर चैलेंज करतो कि चार्ज शीट देबे नि किमति पड़
I have certain document right now I can set be कहजन
आपण कोन फाइल कर दैछन्ती एफआईआर फाइल कर दैछन्ती कॉग्निजेंस ऑर्डर फाइल कर दैछन्ती मझिरे मेन जिनिसटा नाही
सेटा देखि कहै सेते भी कहजन से जे माने यार इंटर ओवर टू इंटरेस्ट पेमेंट कर दिबो
एफआईआर योर वर्जन because it is a complaint case basically.
No, unless she does not make that allegation, FIR cannot be registered or.
That's right, but after investigation, right thing would have come, na?
Yes.
On that basis only cognizance is
That is one part. My whole submission is that it is what you see. What is the if what peruse the allegations that what is the case, my lord? Her case is that he has availed a loan.
आपनकर allegation पर investigation है ला. Investigation charge sheet file की. Let us see the charge sheet, content of the charge sheet.
You file it.
Assuming suppose
cognizance is taken on the basis of the charge sheet.
Charge sheet.
Isn't it?
Yes.
So let us see the charge sheet. आपन file करो.
Also take a time to get.
कौन तो कितने जेबे नेबे नेबे picture से
After 2 weeks, my lord.
और आपन नहीं तो तारे 18 19 नहीं तो.
Take care of class
कौन तो केबे नेबे 29 29 ठीक है 29 yes
item 22
item 22 I am praying for pausing of the proceeding in special GR case number 6 of 23 and my lord alleged offenses under section 376 2N 366 and 363 read with section 6 of POCSO Act. My lord, my humble submission here, my lord, the present affair is a result of counterblast of the civil suit that we have filed before the Sonpur Civil Justice Senior Division, Sonpur, my lord. Here, my lord, there was a previous affair by the same same OP number 2, my lord, and that is at annexure 3, my lord, at annexure 3, page number 29.
What happened to this FIR?
That affair, my lord, there that affair, my lord, the proceeding is continuing. That is under section 498A and 34 IPC against the family members of the present petitioner. And thereafter, my lord, the present petitioner filed a civil suit and inter alia, my lord, the prayer for declaring that the marriage, that the OP number 2 is not the legally married wife of the present petitioner. And thereafter,
in 2023, the petitioner has filed the.
That is the suit you are talking about.
Yes, my lord.
Then come to page 49.
Page 49, my lord, that is the previous.
That is suit.
Yes, my lord.
You are
Page
seeking declaration that the marriage is a nullity.
No, my lord.
Then
Declaration that the my lord, may kindly see page number 58, prayer number 4, my lord. The defendant number 8, my lord, page 58, prayer number 4, 58, my lord. The relevant prayer.
58.
The defendant number 8, prayer number 4.
Hmm.
The defendant number 8, Nandini Giri, be declared as not the legally married wife of plaintiff number 3, Rubul Naik. He is the present petitioner.
For that, why you have implicated 100 people?
No, my lord, there are also some property dispute.
It should just see the memo parties.
Yes, my lord.
19 respondent.
My lord, there are other prayers also, my lord, for declaration of right title, interest, and other things.
You'll also kindly turn to page 28.
No, what is the suit is dated?
Suit is dated.
Suit is dated.
My lord, date is not there, but it has been filed in the year 2022.
You say that the counterblast is counterblast of the suit.
Yes,
is
my lord. My lord, why I am saying so? Because my lord, kindly see at the previous FIR, that is at page number 29, my lord. Page number 29.
20.
And the relevant portion would be at page number 31. That is in Odia, my lord. May I be permitted to place the same, my lord. Moon Nandini Giri, Boyasan, and 19 years. My lord, here she has given her age as 19 years. That is in 2021. It was registered in 2021, my lord. There is also the
Nandini Giri.
Yes, my lord. 31/10/2021.
Now the FIR is by same Nandini Giri?
Yes, by the same Nandini Giri. And now also she has stated her age as 19.
POCSO is
yes, my lord. Only to attract POCSO, she has stated her age as 19 years.
What is the age? Have you investigated?
Your Lordship, that is why your Lordship may kindly turn to page 28.
28.
Yes. Order dated 27/6/2023. 27/6/2023.
27/6.
Lordship, what?
Which page?
Page 28/28, my lord.
28, no?
28.
Okay. 28, yes.
My lord.
Accused is produced.
Accused is produced before this court through escort party. Advocate Sri S.S. Purohit files joint vnama on behalf of the accused along with previous counsel, which is accepted. He also files a petition for time on the grounds stated therein. Hard. Time is allowed. Put up on 6/7/2020. The date is very important. 6/7/2023 for charge. This is a stage of charge, my lord. In the meantime, whether charge has been framed or not, that is, but charge has, it has been, the date.
No, he's saying one thing. You filed the complainant filed the FIR earlier also,
yes,
where she says that I'm 19-year-old.
Yes.
And my lord, in the
now,
earlier
now another FIR is registered, which he is questioning, and there she says I'm 18-year-old, and POCSO is invoked.
Her allegation is that prior to 18, the petitioner kept physical relationship with the victim. 164 statement she has stated. 164 statement is on page 45, Annex 5. Page
164, let us see.
164 statement will also make an issue.
That's in this FIR?
Yes, my lord.
164 in this FIR or the earlier FIR?
No, in this FIR.
Let us see, read it.
Yes, my lord, here she has supported her claim in the in the present FIR, that she has alleged in the present FIR. In the 164 statement, she has supported. But my lord, in the previous FIR,
You'll also may kindly turn to page 6. That is 164 statement at page 45. But the relevant portion is page 46. ଏହା ତା ଆଧାରରେ ଆମ ଭିତରେ ବହୁତ ଥର ମାଧ୍ୟମରେ ଶାରୀରିକ ସମ୍ପର୍କ ଥିଲା। 2019 ମସିହାରେ ମୋତେ 16 ବର୍ଷ ହେଇଥିଲା।
ନାଇଁ ତାକୁ ଓଭରରାଇଟିଂ ହେଇଛି।
ନା ବ୍ରାକେଟ ସେଟା ହେଇଛି। ବ୍ରାକେଟ ହେଇଛି।
ହଁ 16 ବର୍ଷ।
ସେଟା 16 ହେଇଛି।
ଓଡିଆରେ ଲେଖିଲା ବେଳକୁ ଟିକେ
ସେଟା ଭୁଲ ହେଇଯାଇଛି ଟିକେ। ସେ 16 ବର୍ଷ ହେଇଥିଲା। So that is why this and the investigation completed, charge sheet filed, charge has been going to be framed because 27 7 ମାସ ତ ଗଲା ହିଁ। But in the meantime,
And
trial might be
you tell me in the face of that 164 statement, how 482 I can give you.
My lord, my humble prayer will be that POCSO will not be attracted, my lord.
They see 164 statement.
My lord, previous affair was there, and there also charge sheet was.
Those things may be your defense.
And
you may have a very good defense, but just see the 164 statement is staring on the face of the
Right.
court.
And
And-
he is
and my
having
lord, I
ample
have-
time, Milord, to
My
raise
lord,
his
I have
objection.
one more prayer. That the complaint petition that has been filed, it is without affidavit. And
all these things.
He wants it as a test trial charge stage. You file
How will
discharge
you
petition.
get over this 164? That's the difficulty. You have a good case for trial.
Yes.
Not 482.
He is having ample power, opportunities to raise objection at the time of framing of a charge. He should have filed discharge petition.
I can't scuttle the trial at this stage.
That is the whole difficulty. Cognizant state matter would have been different.
All sympathy.
my lord, let me take the instructions regarding the stage of the trial, my lord. Cognizance has been taken. Cognizance order has valid.
Better don't invite any observation at this stage, because you have a good case on what do you call? Because see, the moment you insist for this petition, I have to write something which may prejudice you in the trial, and you have a very good case on merits. It's very unfortunate, but you have a good case on merit. You can be acquitted also. When was the FIR? This FIR?
FIR, my lord.
23.
11 to 20.
Charge sheet has been filed. Charge is to be framed. Huh?
My lord. Charge sheet
July. The date was July.
July.
Charge.
In the meantime, charge might have been framed. And
how much time will you take to conclude the trial? Let's see this plight of this young man. Yes. Try to help him. Try to help him out in the sense, we technically we can't help.
Yes.
But otherwise we can help in the sense expedite the trial and
expedite. Yes. You also may kindly directly expedite the trial. That will solve the purpose of my friend, Lord.
What do you say?
My lord, keep it to next week. I'll take instructions.
By the next week, you also try to find out
yes.
How much, how many witnesses you have cited. Where charge sheet you have filed?
Charge sheet ଅଛି ଦେଇଛନ୍ତି
charge sheet file ଅଛି ଆପଣ ପାଖରେ?
yes charge sheet ଦେଇଛନ୍ତି ବୋଧେ
କେତେ witness cite କରୁଛନ୍ତି prosecution ଆଉ କେତେ tentative time ଲାଗିବ ଦେଖନ୍ତୁ ନା
charge sheet ଦେଇନାହାନ୍ତି.
Just tell me so that we will take a overall view and ask the trial to be concluded. He is on bail?
Yes, ma'am.
He is on bail.
So expedite करके trial
expedite करके matter ends.
Unnecessary you invite some observation from this court at this stage, it will prejudice you in the trial.
Exactly.
We'll keep it next week.
Yes, my lord.
Two things you tell me. How many witnesses are cited? And he will seek instruction how much tentative time it can take for the purpose of conclusion of trial. You are on bail.
Yes, ma'am.
Let us expedite the trial, and so that
only the if you also direct to expedite the trial, then it will be better.
Let us understand how many witnesses there.
Yes,
because there are a lot of suits.
Yes,
that there are a lot of things are involved. Factually, a lot of things.
Right.
So the prosecution may take a little more time also, because the story is complicated. There is a suit, earlier FIR, so many things are there. So looking into the facts, complicated facts, because there is animosity between both the parties. The trial may take little more time.
Yes.
So let us understand instead of
how many charge sheet witnesses are there.
Yes, we should know that next week. Next week. That is on 9th. 9th. Simply adjourn 9th. ठीक है. Item 23. Yes. There are defects here. Hmm.
23.
First.
24.
Pass out.
25,
Pass out.
26,
My lord, on behalf of Mr. Panda, my lord, kindly take up the matter after 1 week.
1 week.
Oblige, your lord.
Indeed.
27.
27.
Yes.
Petitioner prays for casting of the entire proceeding, your lord. So in this case, on different grounds that 161 statement and FIR story are completely different in this case. So I'm submitting the
164 and 161.
161 statement and FIR story. I'm submitting the
That's the ground.
Yes,
FIR story not matching with 161.
Yes.
You confront the when
completely
the evidence
different,
is
your lord.
taken.
So may kindly go through the FIR first.
This is what? This is FIR.
This is the 161 statement of the.
Oh, then I can't in the 482 I can read the 161 statement and pass it.
Charge sheet has no, charge sheet I have already.
You very good. You want to confront all these things.
No, charge sheet already been there. That is at annexure 2. I am praying for questioning of that charge sheet, your lordship. Because FIR law under section 498, 294, 323, 506.
You are husband?
Yes, I am.
On bail?
Yes, I am. And charge sheet submitted under section 498, 294, 323, 506 and 406.
Where is the charge sheet?
That is at annexure 2, page 17.
Let us read the charge.
Charge sheet filed on 23/9/2022. Charge has not been framed till date.
Read the content of the charge sheet.
Content of the FIR. May I?
Charge sheet now read. Now charge sheet has come. Now just see.
Yes, charge sheet content. During course of investigation, the spot was visited. A complainant and other witnesses were examined who well proved the occurrence, seized marriage proof documents, articles list in respect of marriage of complainant with accused, husband Bhagavat Prasad Bhaiya. The accused misappropriated this Sridhana and shifted to another flat without the knowledge of the complainant. Hence, section 406 of IPC added against him. The accused surrendered before the SDA such and such, submitted compliance report such and such. That is the charge sheet schedule. That is the
where is demand of dowry, where is harassment, where is
that thing is there.
There is nothing. What kind of investigation is this? Not a single whisper. Demand kortil dowry, harassment kola. There is some word at least somewhere. What is this?
2 lines complete.
And then you put him to trial for this. Single whisper about 498. Single whisper. He harassed or something. See the FIR now. Let us see. Come to the FIR.
FIR story is.
This has to be quashed, sir.
FIR story is.
Can't allow. It's a wastage of time.
Yes.
Wastage of time. କିଛି ତ ରହିବା କଥା କିଛି ଟିକେ ଗୋଟେ line କୋଠି.
The charge sheet is mentioned on but so far the other documents.
Show me. If that is there, then we will.
I'll get the CD, Lord. I'll get the CD so that your lordship will satisfy.
CD
In what extent the investigation?
Hey, charge sheet re kichi no likha thai pare, but the materials are there. Then
may kindly go through the FIR story.
That
let us see the FIR story.
FIR story. My elder brother, my paragraph.
Chinmay Kumar Pera. Read it.
Chinmay is about 40 years, who also working as Bangalore. He had purchased a house there. He got married to Srimati Rispa Sahu, aged about 32 years, on 11/2/2010 at Berhampur, and was blessed with a son. Thereafter, my elder brother, along with his wife and son, used to stay in Bangalore. My husband frequently visited to my eldest brother's house during his absence and developed his intimacy with my sister-in-law. Sister. After that,
I'm reading, Lord. After that, my husband started torturing me for no fault of mine. He gave me mental and physical torture and forced me to sign from my job. I was working at IDBI Bank, Bangalore. I left the job under compulsion and to save my married life, as he was threatening to kill me and my family members if I continue that job. He had provoked me to multiple times to commit suicide. While the matter stood as all our family members had gathered at Barampur on behalf of the first death anniversary of my parents on 4/5/2022. After performance of the death anniversary, my sister-in-law, along with my brother, went to her brother's house at Govind Vihar, 10th Lane, near Ruby Eye Hospital, Barampur, Sadar, PS on dated 6/5/2022. My husband had come on 30/4/2022 to Barampur, but neither he visited our house nor contacted me. On 2nd and 3rd May 2022, I chatted with him on the mobile, but he told me that he was in the flight. Thereafter, he disconnected all the links with me. I beg to report that on 6/5/2022, my elder brother dropped my sister-in-law along with his minor son at his brother-in-law's house. Next day, on 7/5/2022, my elder brother went to bring her back. At that time, her parents intimated that she did not come at all. We further inquired into the matter and came to know that she had gone to Bangalore without any intention. My elder brother, intimation. My elder brother lost affair on 8/5/2022 at Barampur Sadar PS. She switched off the mobile and did not respond to the phone calls
Allegations are there.
police.
Here also no demand for dowry, nothing else.
Now my
mental harassment because you developed relation with your
No, that is also wrong. That's why they are trying.
But these are the allegations. After investigation, what?
Yes, go through the one step.
One minute. Here also may kindly see clearance number 1103 of 2023. What is that? What is that? My friend will say
That is an order. I have withdrawn the application, but order has been passed by the honorable subject. So they are the all the results and the kind of charge, the minimum charge. So it's not hard, but after that I received that connection code. That is restriction of original rights from the community.
Oh, no, where is that order?
Yes, exactly.
Where is that order? Category you got from order.
Like that is this is
already been passed.
Yeah, but
because
that many kindly to recognize the
why should you have an order already?
No, because there is nothing in the FIR statement, charge sheet.
And also you approach the court, you got an order.
No, I haven't mentioned that. So
You mentioned
earlier I have.
Where is that order? You show me the order.
Technically taken up tomorrow day after.
These are minimum thing. You are disclosing that you have already approached 482 court earlier.
That but order has been passed. I have withdrawn to file a better application.
I'll tell you what happens. I'll tell you what happens. In the criminal case, we don't read the pleadings. Naturally, we have to read the evidence and all. And we pass some order, then tomorrow it will be blamed to the court that see the court has not applied tonight.
Yes.
The fact remains that you people have not told us.
No, I have
And
mentioned.
thereafter I have mentioned in the first line.
Already approved. I have already mentioned.
No, this is minimum. Once you have filed it,
One bail application and one criminal mistake.
where is the order? That the order has to be.
Day after tomorrow,
At least the order that
may kindly confirm that.
No, we will not.
No. This honorable court order.
No, it's not right, but you have filed 482 repeatedly. Second time, you don't file the first 482 order. What is
mentioned, but not
mentioned?
I'll take it to day after tomorrow. I'll give it.
Yeah.
Alright.
This is very unfair to the court.
No, it's mentioned.
I mentioned it's all right, but we are see. Suppose I pass some order, which will be contradicting the earlier order.
That is the ventilated grievance which will be lower for at the time of the charge. That is the order.
Then you have to ventilate whatever.
Because there is nothing in this FIR.
That's why the court says that you won't ventilate.
Let it put it forward.
One application for discharge. Next.
After tomorrow.
On behalf of SCT, my lord, we have some personal difficulty.
Copy not solved, my lord. Adjourn copy, supply the copy.
I'll come.
There are defects also. Any defects?
It will be removed.
39.
Yes.
There are some defects. Ignorable defect 313. Synopsis is not filed. Synopsis. Synopsis file वाला. लेकिन so अटक गया. हाँ that way. This is file. Not file without what is the order once? That will copy. This one tell me down when it is time. But in this case, my lord, the prescription was granted bail by this honorable court. This deposit 5 lakh rupees into the deterrent. Thereafter, after release of 3 months, it has to deposit another 15 lakh. As per the allegation of the complainant, that he has taken 14 lakh to sell it. Thereafter, madam, the present petition of that modification of the order, this court accepted that modification and allowed to pay only deposit 10 lakh rupees. 20 lakhs is reduced to 10. 15 lakh. 5 lakh first, then second 15 lakh, 15 lakh, 10. Thereafter, what happens, my lord? The court has taken imbue. Because the court had saying, my lord, the court never said not to take the imbue. My lord, kindly page 9, man. Kindly come once again. Yes, I am coming. Kindly come to page 9. Page 9. Yes. Kindly come to my lord, page 10, paragraph 10. Without prejudice to their rights and the conscience, directed the petitioner for deposit 5 lakh cash settlement. Put their release, which shall be kept in the short term interest once. Further, after 3 months, the release balance 15 lakh. Then, my lord, kindly comes to page 14. Petition shall deposit a further sum of 10 lakh in 5 equal installments. First installment shall be after 4. 1 minute. Where are you reading? Page 14. Paragraph 6. 146. Considering such submission, the bar, the court is persuaded to modify the paragraph 17 and so 10 lakh. Okay. 10 lakh in 5 equal installments. First installment shall be 4 months of the release. But there was 3 months. Now it is modified to 4 months. That 4 months started from the 2nd of November. So it's 2nd of December. So the 2nd of November, the lower court issued imbue. That is the point. Madam, kindly come to page. Page, my lord. Annexure 3, page 15. I saw that. Order dated 2nd November 2. Yes, madam, kindly come to page 16, my lord. 16. Violation of order to order, hence in view of the above order. Violation of what is that? Violation of order to court order. Violation in view of the. Hence, in view of the above order, on the court issued immediately against the accused person. When was the first installment due? The first installment due was 2/11. After my modification, it was 2/12. So, I kindly come to and 2/12 we have been. Yes, we have been. Yes. Yes, sir. Do you want to say anything?
So kindly see page 20.
0.
Before that, page 19 from second para and third para I am reading. Also can see. Yes.
How much you have already deposited?
Deposited
because today is another day.
Depositing.
No, since you are malad, it becomes the malad that we have obtained.
What is this? What is this? What the bail?
Yes.
Modified the order.
Violation of the order. This is not the depositing, question of depositing and not depositing is not a matter. Because it's a violation of the order passed by this only. That is why order dated 18/11/2023. সেটা মডিফাই কলা পরে মধ্যে আপনি দেন না
বাট না মডিফাই কলা পরে দিয়া হইছে
কিন্তু সেটা পড়ছি
which page you are
page 19 order dated 18/11/2023
which item, yeah? Item number 29, na?
And
what was the consequence of not depositing?
but I'm reading page 19, order dated 18/11/2023.
Yes, 19 years.
Lordship, what is
18/11.
18/11. From, but I'm reading from, let us know that I'm starting from the beginning. This order arises out of petition dated 15/11/2023, filed by learned advocate for the accused person, saying to recall the order dated 2/11/2023, passed by this court. Copy has already been served on learned APP. Third, learned counsel for the accused person are submitted that the accused person were released on bail by this court as per the order of Hon'Ble High Court of Orissa, with a condition to deposit rupees 3 lakh in favor of a registered civil courts cutoff on 2/11/2023, 2/12/2023, 2/1/2024, 2/2/2024, and 2/3/2024. He has further submitted that in the meantime, the accused person filed an application before the Honorable Court for modification of the Honorable Court's order, and Honorable Court has modified the order passed earlier as per the modification order of Honorable Court. The first income of the payment is due on 2/12/2023. He has further submitted that due to non-payment of rupees 3 lakh on 2/11/2023, these courts issued imbue.
Yes. Now, when it was paid to reduce to 2 lakh.
ଆପଣ ସେଇଟା କେମିତି ଅର୍ଡରଟା ମୋଡିଫାଇ ଅର୍ଡର ଏଭିଟେବଲ ହେଇସାରିଲା ପରେ ଯାଇକି ଆପଣ ମୋଡିଫିକେସନ କରିଛନ୍ତି?
Modification was done on High Court, my lord. That
ସେଇଟା ଆପଣ କୋର୍ଟ ନଲେଜକୁ ଆଣିବା କଥା କୋର୍ଟ ନଲେଜକୁ ଆଣିବା।
Now the court has modified the order.
That
He is ready to pay. Why NVW?
Yes.
Let him pay. Ultimately, he has to pay the trial. At the same time, he is paying. Now the Supreme Court has said that this honorable condition of deposit and all is not tenable.
And whether he is,
But still he is
paying or not, I
giving
don't-
it.
but the order does not show that whether he has paid or not.
we are not have to.
He is waiting for today's order.
Yes.
So that he pay.
Hey, once we have paid, my lord, on the 2nd of December, we have paid 2 lakh, sorry, 2 lakh rupees. Today is the 2nd of January.
କେମିତି ଆମେ ଜାଣିବା ଯେ
Then I submit the paper. I will, you don't know your knowledge.
So the first order. The first order is Justice Nothing that is on. Therefore, the petitioner is seeking which is the NVW order.
My lord, on page
20.
no, my lord. Page that is page 16, my lord.
16 is the order you are challenging.
Yes, my lord. 16 and page 2.
Huh?
Page 16 and page 2. Annexer, my lord. Annexer 3 and Annexer 5.
No, petitioner is challenging.
Yes, ma'am. Annexer 3, Annexer 5.
Order dated 2/11/2023 and 18/11/2023. By which the trial court has issued NBW against him for non-compliance of the order of this court passed on 17 passed on
14 July
17/8/2023, which has been modified. No, first order
14/7/20.
14/7/2025, 23.
Yes.
Which was subsequently modified on
17/8/2023.
The petitioner has been granted bail by the coordinate bench of this court with a condition that he should deposit 10 lakhs in 5 installments, equal installments after 4 months of his release. He has been released subsequent to the said order, and the first installment was supposed to be deposited by the accused on 12/2024. Meanwhile, the trial court misconstruing the said order the High Court granting bail to the prisoner issued imbue against him. Yes. Against them, against them, Who against them. Therefore, we approach this court by filing the cease. Therefore, they have approved this court by filing the present petition. Next one, the council appearing for the business admits that the petitioner is ready and willing to deposit the installment as directed by the trial court as per the due dates in this, and he accordingly undertakes to comply the orders of the coordinated bench of this court passed on to the date and modified in situation. Currently, the order dated 2nd November 23. Again, 2nd November 23 and 18th November 2023. 18th November 2023. Stand fast, and the petitioner is guilty to appear in the court. Not before. Stand fast. Yes, and can I pray one thing? And today is the date. Can it extend to another 1 month? I can't extend it. Same good thing. I can't. Because that will be a clear purpose. I can't. Stand fast. If you don't pay, then again peanuts of supply the copy.
I mean, more than 5 crore withdrawal.
May I please?
That is the first, at least. Personally, can you see?
Memo, withdraw copy.
May I please your lordship? Lordship, I may be pardoned. Lordship, I may be pardoned.
2 o'clock.
2 o'clock. How many matters are there?
Huh? 6 matters are there, some mentioning and all. 2 o'clock. Yes, okay. Thank you.
Submission. My lord, I have.
No, there is some mentioning. Mr.
Yes, my lord.
Murthy was mentioning the afternoon.
Yes, madam. Yes, my lord. That is CRLMC
Yes,
number.
Murthy.
Yes.
You are
Yes, my
mentioning
lord.
something.
Yeah. CRLMC 4724 of 23.
Yes, yes.
Though it has never been listed, my lord. It may kindly be taken. It's only at the stage of accused statements, a warrant was issued. That's all. Well, I
Accused
have-
statement, what happened? Accused statement?
He did not appear. He couldn't appear.
Okay.
That's it. So I'm just praying, Joe. It may kindly be listed shortly.
Which
47
date?
472.
5th?
Yes, my lord. Yes, my lord.
Beg pardon?
CRLMC,
Mr. Murthy. T.N. Murthy. Case number?
CRLMC 4724
4724.
of
On
23.
5th. On 5th, that is Friday.
Yes, my lord.
Beg pardon, my lord. I am mentioning one CRLMC, my lord. The petitioner filed for this 482 application for default bail, your lordship.
Default?
Default bail, my lord, under 167 subsection 2.
But in 482, you are filing.
My lord, the 482 I am filing this matter.
Shortcut way.
My lord, here what happened, your lordship, the petitioner.
We'll
learned
see
court.
that. Let it be on 4th.
Grateful, your lordship. My lord.
Fourth,
I will file the memo, my lord.
Case number, you file.
I will file the memo,
Where
your
is the
lordship.
memo?
I will file the memo, my lord.
During the course of the day, you give.
Yes, my lord. Grateful.
Yes, Mr. Devaratho, item 23. Okay.
I may. Lordship, I have skipped due to glitches, due to technical glitches, the item number 23.
23, yeah? Password? Then just I'll call you. It's a password. We'll call you. Next.
Item 2.
2. Very good. What happened? This matter. What is he asking?
Quashing of Maladaji.
Quashing of?
Proceeding. 307 other sampans are there.
February.
So
Date February. February end. Well, they're not interested, then February end.
Item 7.
Compromise. Now, what is the offense? .307 is there. What is the injury? Simply then the 307 simple. 323 is the simple. And compromise is also while taking wine. That's the problem. While compromise has to be seen whether taking wine or not. What is the relationship between them?
There are 4 petitioners.
The accused, there are how many accused? Except 2, huh? Except 2. Okay. রাজিনামা কে কে করছেন? Govinda, the informant is Govinda. Samanto Digal. Show me the what you call it now. Samanto Digal. Yes.
My lord, the 307 is there, my lord, but the first date case date not there. That what you know, they have to file joint affidavit for this. So it will better, my lord.
No, settlement they have filed.
Settlement they will file, my lord, before the both commission, my lord. Joint affidavit will better, my lord. Tomorrow, for the joint affidavit, the better, my lord. First times, my lord, sometimes, my lord.
Because again, while drinking they fought.
Without
drinking
since my lord, without notice,
and again they will drink and they will say that I have not.
My lord, submission, my lord, without notice not been issued. Whether the informant properly
identified.
No, I just saw
My
the
lord,
signature.
that is true, my
It's
lord.
Rajinama
So-
signature.
Sometimes, my lord,
You're right.
they have to file, my lord, joint affidavit.
File it tomorrow.
If lordship wants, my lord.
Day after tomorrow. The
But since 392 is there, for that is no.
307, that is
If possible, if they will appear before the lordship, personal appear, it will better, my
will
lord.
they appear tomorrow?
Or virtual, my lord.
Virtual mode?
आयो थाना लोकल थाना रे आयो आइडेंटिफाई कर दो
आयो हां से कर देना
लोकल थाना रे काली रखि दो तो आयो आइडेंटिफाई कर दे तो पछा देबे जदि आयो कहबे ठीक कंप्रोमाइज है
पछाइले सरला काम फ्राइडे विल दे अपीयर हां जॉइंट पिटिशन
अपीयर कर दियो ठीक ना अदरवाइज थाना रे अपीयर करले हमें आयो लिंक दे देबा
I what I suggesting is joint petition you prepare appear before the IO. He will verify and then I will call you. Land counsel for the petitioner submits petitioner is accused. Petitioners are the accused. How many petitioners? Petitioners are the accused in FIR number, case FIR number so and so. What is the stage of trial? The investigation in the case is progressing. At this stage, the informant, oblique the victim, and the accused persons have entered into settlement. So the land counsel for the petitioner submits that the informant is the brother-in-law of the one of the accused. To buy peace and tranquility, they have entered into a settlement. Mr. Patnaik files Wakalatnama on behalf of the informant, that is opposite party number 2. Same is taken on record. Both the parties have agreed. Both the parties jointly request the matter to be adjourned so as to enable them to file a joint affidavit. Joint affidavit. Next one. The petitioners and opposite party number 2 shall file a joint affidavit to be presented before the investigating officer, who shall verify and communicate the same to the land counsel for the state by next date of hearing. Next program. Matter is adjourned to 5th January to enable the parties to file the said joint affidavit. ठीक है. अब बनेगी आयोग को दे देवे से आयोग वेरीफाई करेंगे.
सेटी करले अपडेट चलेबो लोकल सेटी करके दे देले
सेटी कर दियो आछा दर कर सेटी करके आयोग को दे देले
आयोग वेरीफाई कर
मत कह देले
आगे इन्वेस्टिगेशन कर बेल लाख किछ होबन.
The person who is supposed to take coercive action, he is drinking with you.
नाही 5 तारीख काय हो से किछ करिवेनी.
He is there, why do you?
आगे मालो
Item 15.
से वर्चुअल अपेयर करथले काय नाहंती दिल्ली मिस्टर दिलीप राय
My lord.
Somebody was appearing.
Yes, my lord. I am serial number 15, my lord.
Right now.
Right.
Within half an hour, you will get it. No. But orally you can communicate. Joint affidavit तो settle कर दो ये जो राजीनामा टा लगेगी तो कर दो. 2 minutes काम. आयोग को जाके दे दे आयोग को फोन कर दे लेगा.
item 15 से हम copy देना दिया उससे.
serial 15 my lord.
But you have not given a copy to the council.
My lord.
In course of the day, my lord. In course of the day, I will give.
In the course of the day. But what is this matter? Without
And the
copy also
matter is,
we can dismiss. If
my lord,
we can. What is this matter is about?
and for passing of the cognizance, my lord. My lord,
Then you give a copy.
Yes, my lord.
Give a copy.
In course of the day.
Course of the day.
It may come day after tomorrow or any day, my lord.
Day after tomorrow?
Oblige.
4.
23.
23. Yes.
May I plead, Your Lordship?
Defect
Am I
number
audible?
6. Copy
Lordship?
मिलती है आप लोग?
Yes.
Yes.
Yes, Lordship. Lordship, this matter, though 307 is there, this is the matter raised out of a family discord between husband and wife. And the husband, wife has lost one case against me. Wife has filed a divorce petition against me before the Hon'Ble Jaspur Court, Jaspur Family Court. Lordship, one co-accused is already here. My ABLA appeal was rejected on 20th April 2023. The Honorable Justice T.R. Das has clarified that since the injuries sustained by the injured are grievous in nature, that is why my ABLA appeal was rejected. On the same day, one co-accused was released on bail. Released on bail means he was directed to surrender before the court. That I have annexed in the annexure 2, Lordship.
That is Prakash Chandra Rao.
Lordship.
Prakash
My only prayer is that with parity I may be allowed to surrender before the court. Lordship, the important point I have forgotten to.
But why 482 for that?
Exactly.
Lordship, ABLAPL was rejected priorly.
No. Then you have to go to the bail court. This is not bail court. 482.
Yes, Lordship. I know, Lordship, but it was supposed to be
You want parity with Prakash Chandra Rao.
Yes, Lordship.
Prakash Chandra Rao case, what the case that is made available?
Prakash is not the husband and he is not the assailant.
Assailant is.
I am also not the assailant.
Is the petitioner. He is the husband. He
No.
assaulted brutally.
No,
Who is this Prakash Rao?
Prakash Rao is one of my friends.
Your friend will get in your marital dispute. You are the husband. You have
No,
attacked.
Lordship, both were staying at different places. Their allegation. Actually, the person who has alleged.
See the FIR. Come on.
Yes.
Let us see the FIR. Let us see the FIR. Allegation. Read it. Read the allegation. Read the allegation. On 7/3/2023 at 9:30 p.m. Read it out.
Lordship.
ଆପଣ ପଢିଯିବେ।
My lord. ଗତ 5/3/2023
12
yes.
Entry 12 in FIR page number 10.
Page number 10, that is no, page number 10 is not there. Page number 13 is the
ଚାଲନ୍ତୁ 13 ପଢନ୍ତୁ।
fine. ମୁଁ relevant portion 5
page 10 ଦେଇଦେଲ
ହଁ ଗତ ତା 5/3/2023
page 10 ନିଅନ୍ତୁ।
my lord.
ଇଂଲିଶ ରେ ଯୋଉଟା ଲେଖା ହେଇଛି।
Yes. Complainant Narayan Samal, son of Gayadhar Samal of Sri Singhpur.
12 number entry.
Yes. PS Kuakhia district Jaipur reported that on 5/3/2023 at 10:30 p.m. his wife and other family members were present in his house while his daughter Rasmita Das to attend past urine. At that time, her husband Suryakant Das assaulted her by means of deadly weapons in order to kill her in life. As a result, she received sustained bleeding injury on her head. Then she made hulla and her wife came to the spot. At that time, the accused Suryakant Das abused her in obscene languages
and also assaulted her with a deadly weapons, and she received bleeding injury, and they have been fell down on the spot. Then the other persons along with the accused Suryakant Das assaulted them and fractured the hand of his daughter. His family members shifted them to CSC Dharmasala for treatment, and the doctor referred them to SCB Medical.
There is direct allegation against Suryakant.
Yes,
Das.
yes, yes.
That you are the person who dealt, and the other person also attacked.
No.
The other person along with the Suryakant assaulted. The Prakash Raut is one of them, other person.
Yes. That's it. But Lasip, after that, police has investigated the matter. Police has informed it to the police, though charge sheet is not been filed. But I was not I have not assaulted my wife on that day because I reached at a very later stage.
The allegation is direct
Yes,
against you.
the allegation is direct. Unfortunately, the person
At this
who has
stage,
alleged,
charge sheet is not filed. We have to go by the allegation.
yes, Lordship. That is why I am saying, Lordship, unfortunately, the person who has alleged, that is the informant, that is the opposite party number 2, who expired yesterday only, Narayan Samal, my father-in-law. And that too, Lordship, interestingly, I have taken all the charges of his cremation yesterday only. It may be on coincidence, but
You have the
yesterday.
son-in-law. You have the son-in-law. You have to do that. What is the? Is that a ground for quashing an FIR?
But my wife has lodged one divorce suit against me.
How these facts will count for this petition? I don't know. You want a complete quashing of the proceeding. I think you have a better course.
Yes, Lordship, I have a better course. But here only I pray that I may be surrendering before the court, and I will try my luck there.
By these facts which you have told, why don't you apply for anticipatory bail?
I had filed, Lordship.
Where is that order? Which is rejected?
Yes, Lordship.
Where is that order? You have not filed that also.
No, I have not filed. That is by 2500 of 2023. Lordship has clearly rejected that state submits that.
What is the number?
2500 2023.
23 ABL.
See that order. Show me.
ABL.
No, this is interim. Thereafter,
final order.
Huh?
This much is uploaded.
Dismissed, na?
This much is uploaded.
This is your plan, but this petition is dismissed. See, you got interim protection on 22nd March 2023.
Later on, it was rejected, Lordship.
When? Date, you tell me this.
20th April 2023.
20th
April 23. Order is not uploaded.
What is the order of this Prakash?
You have only directed to surrender and move
Yes,
further.
What do you say? He is only asking parity. It's a bail application in disguise, basically.
Yes. That is why.
And the mitigating factor is the informant has now died. It's a family dispute.
Wife is alive.
Wife is alive, but the informant is the father-in-law.
Yes, father.
He died yesterday.
Yes.
and suppose he is taken into custody, the relationship will be more hostile. So in that situation, I think we should extend little bit.
Parity or something direct for parity.
That's the only, I'm not getting.
Yes, yes.
I'll record his statement and dispose it up.
Yes, sir.
Instead of giving any direction.
Yes, yes.
That will serve his popular.
Yes, yes.
See, the
Yes,
idea
sir.
is it is a family dispute.
Right, madam.
Yes.
If he is taken into custody, the hostility will increase. If there is little chance of reconciliation, that also will be spoiled. Let us save this person. Otherwise, he is not entitled. But only to,
Yes.
So, Lordship, coincidentally, that time has occurred.
Anyway, but you are not entitled to anything because you
I
have
know,
assaulted
Lordship.
your wife. But
I
what
know,
to do
Lordship.
now? That's very. Petitioner is accused in FIR number so and so under section, all the sections. That is at base 8. Full stop. It is alleged against the petitioner that he has assaulted by means of a deadly weapon in order to kill his wife. In the act, other persons have also accompanied the petitioner. The informant, the author of the FIR, the author of the FIR is the father-in-law of the petitioner. The learned counsel for the petitioner submits that the father of the petitioner has been submitted. The father of the petitioner, being the informant, has been implicated as a respondent number, opposite party number 2. Learned counsel for the petitioner submits that respondent 2 has died yesterday. And
Yes.
yesterday. The informant, being his father-in-law, he has the last rights and other functions have been conducted by the petitioner himself. And petitioner himself. So the petitioner is also facing a divorce proceeding being initiated against him by his wife. Meanwhile, he had applied for the anticipatory bail by way of anticipatory bail. The coordinate bench, while granting interim protection, the coordinate bench initially granted interim protection on 22/3/2023. However, on 20th April 2023, the anticipatory bail application has been rejected. Rejected. Next paragraph. On the same day, that is on 20th April 2023, other co-accused person in the FIR, namely Prakash Chandra Raut, also applied for the bail. The coordinate bench, while order dated 20th April 2023, directed the co-accused person to surrender before the court, surrender before the trial court, and the trial court is directed to
dispose of him on merit.
Like parity
No.
consider the bail application of the petitioner in the first hour. The trial court has directed the petitioner to surrender, and his application shall be considered on the first hour of the day, subject to verification of the criminal antecedent, strictly on the basis of the material available on record. Record full stop. In case the application is rejected and the petitioner may move his bail application to the next hierarchical court, and the same shall be disposed of in the second hour of the same day. Second hour of the same day. Full stop. Next paragraph. The petitioner, although argued the case on merits in this merit, however, he only prays that he may be granted the same relief as has been granted by the coordinated bench to the co-accused person, without expressing on merit. The trial court may consider the bail application of the petitioner once he surrender, drawing in the same manner as has been dealt with in case of the co-accused.
Yes.
As has been dealt.
Within a period of your lordship may fix up the time.
The petitioner is directed to surrender within. କେବେ surrender କରିବେ? Next week?
এটা 10-15 ଦିନ ସୁଧଘରଟା ପଳେଇବ।
Within 10 days.
Yes.
ଚलो ସେ ସୁଧଘର ପରେ।
15 days.
ଏବେ କାଲି
15 days on.
Yes. 10 days ତାଙ୍କର ଅଛି
within 15 days from today.
Yes.
The petition is disposed of with the aforementioned observation. There is no impediment. You can very well surrender.
My lord, yes.
24.
24. Nobody there?
Nobody.
February and
25.
Next week. Next. Finish.
My lord.
Is it?